To be honest,
So here's what we're going to do. We'll order you to serve a minimum term sentence of Ms. Broders is present in court, out of custody. I have received a report from your probation officer that says that you have violated the terms of your ILC. Officer Nelson, could you read those allegations for me, please?
The allegations are the defendant violated ILC condition number 7 on October 14th, 2025, submitted to a drug test which was positive for marijuana and alcohol and admitted to use. On December 5th, 2025, submitted to an oral swab which was returned back from the lab confirmed positive for marijuana. And on February 17th, 2020, I think that is supposed to be 2026, but it says 2025, verbally admitted to using marijuana and drinking alcohol, was ordered to submit to a drug test, and left the office without testing.
All right, Ms. Broders, do you understand the allegations?
I do.
You have a right to be represented by counsel. If you cannot afford an attorney, I will appoint one for you at no cost. Do you have the funds to hire an attorney?
I do not.
Do you want me to appoint you one?
No, it's okay.
You want to waive your right to counsel?
Yes, that's correct.
All right, there's 2 forms in front of you. The one that says waiver of...
We are stepping straight into a courtroom where things escalate from the very first second. The judge begins by announcing a minimum term sentence and immediately shifts attention to serious probation violations. The probation officer lays out multiple failed drug tests involving marijuana and alcohol, including missed compliance and admitted use. The defendant is then confronted with the reality of her violations while being offered legal counsel. But what makes this moment intense is her decision to waive her right to an attorney, choosing to face everything alone. That single choice instantly raises the stakes in the courtroom. Every word now carries full legal weight, and the atmosphere becomes far more serious than a routine hearing.
Counsel is the one you need to sign for me, please. All right, Ms. Broders, is that your signature?
It is.
Do you understand what this document says?
Yes.
Has anyone promised you anything or threatened you in any way to get you to waive your right to counsel?
No, Your Honor.
Are you under the influence today of any drugs or alcohol?
No, Your Honor.
Do you take medication that interferes with your ability to understand what's going on today?
No.
All right, I'm going to make a finding then that you've made a knowing, intelligent, and voluntary waiver of your right to counsel, and I will accept that. Now, with regard to these allegations that Officer Nelson read, do you admit them?
Yes.
All right, the court's going to find that you have violated the terms of your ILC. What seems to be the problem, Ms. Broders?
Well, to be honest, I do suffer from bipolar disorder. And at the same time that this case was ongoing, I have suffered from major domestic violence from the father of my children, strangulation and more. I've moved across the state of Ohio to Cleveland, alone. I slip sometimes. I'm sorry. I don't mean to get emotional. Sometimes the medication that is prescribed to me by my psychiatrist is not enough. I do tend to self-medicate when I'm going.
After admitting the violations, the defendant begins revealing the struggles behind her actions. She speaks about bipolar disorder, severe domestic violence, and traumatic experiences including strangulation from the father of her children. The courtroom shifts as her voice becomes emotional and unstable. She explains how she moved alone across Ohio and how she struggles to cope daily. This is where the case stops being just about probation and becomes a story of survival and mental health. The judge listens but continues to maintain focus on accountability. The emotional weight here is extremely heavy, showing how personal trauma and legal consequences collide in real time.
Going through a hard time.
Let me stop you for just 1 second. Have you discussed with your psychiatrist your use of alcohol and THC?
I have.
And he or she says what?
Me and my team have agreed that I'm not going back to NA. I have been appealing.
Well, you didn't answer my question. What I want to know is, does your psychiatrist who prescribes you medication for bipolar disorder know, or does he have an opinion with regard to your use of marijuana and alcohol? Yes or no? Does he know?
It's not recommended.
It's not recommended.
By her, no.
Her, okay. So I'm telling you right now that I have ordered you that you are not permitted to use it. Now, you're obviously not following your doctor's advice, because I've read the studies, and I am 99.9% certain that any legitimate psychiatrist or medical doctor would never prescribe the use of marijuana. They don't. The ones that do are quacks, and they're online. You are not allowed to use it. It's part of my order. Do you understand?
I do.
So here's what we're going to do. I am going to today continue you. I'm going to continue you on ILC. You actually should have been done with your case by now, but you, for some reason, you're dragging your feet. I'm going to continue this. I'm going to continue you on ILC. I'm going to give you one more chance to get this right. Now, I'm going to set this for a review hearing in 90 days. In 90 days, you are ordered to appear in my court again, and you're to test today.
The courtroom tension sharpens as the judge begins directly challenging her behavior and medical choices. The defendant tries explaining her treatment, but the judge repeatedly interrupts, demanding clear answers. The focus shifts heavily toward her use of marijuana while being prescribed psychiatric medication. The judge firmly questions whether her doctor approves of this combination, pushing for a direct yes or no response. When she admits it is not recommended, the judge immediately rejects any justification. This is where authority becomes absolute, and the tone shifts from discussion to command. The judge declares that marijuana use is not permitted under any circumstance, escalating the pressure and removing all ambiguity from the case.
You live where now?
I live in Cuyahoga County, sir.
So when you come back in 90 days, if you're still using marijuana, you're going to go into custody. Are we clear? Are we clear on this?
Yes, sir. I did want to say, Your Honor, I did already drug test today.
You did drug test today?
Yes.
And it was?
It will be positive for marijuana.
Okay.
However, I did stop smoking from my last
Okay, so 90 days should be plenty of time for that to get out of your system. So you have 90 days to get this cleaned up, or you're going into custody, and I'm going to sanction you. You have no idea how the high levels of the concentrate of THC is affecting both your mental health and your substance use disorder. If you have bipolar and you're using marijuana, it is contraindicated. It is not healthy for you. I am trying to help you here by forcing you to stop using it. So you make a choice. Either you stop using on your own, or I can arrange so that you don't have access to it in the county jail. Your choice. So that's the order. You'll be back in 90 days for a review with me. But understand, if you're still positive, I'm taking you into custody. You understand me?
Yes, I understand.
All right, that's all.
Thank you.
The most critical turning point of the entire hearing. The judge issues a final warning. She has 90 days to change her behavior or face jail time. But instead of improvement, the defendant admits she already took a drug test that will still come back positive. That confession completely shifts the outcome of the hearing. The judge explains the risks, linking marijuana use to mental health decline and repeated failure to comply. He gives a strict ultimatum: stop using or go into custody. The pressure here is intense because the consequences are no longer hypothetical. The defendant is now standing at the edge of incarceration with only one chance left.
If you may have you, your officer.
Ms. Broders, this is how you wish to proceed.
Yes, sir.
All right, Ms. Tranter.
Your Honor, these offenses occurred January 8th, 2026 in Warren County, state of Ohio. On that date, defendant did by force, stealth, or deception trespass in an occupied structure or separately secured or occupied portion of that structure when another person other than her accomplice was present or likely to be present with the purpose to commit any criminal offense therein. She was also in possession of a scheduled substance, being heroin, in the amount of 0.52 grams.
The final section transitions into a completely different sentencing case, raising the stakes of the entire video. A new defendant is introduced facing serious charges including burglary, heroin possession, and theft by deception. The judge reads out detailed legal findings, showing a clear pattern of criminal behavior and prior considerations. After reviewing sentencing factors, the court delivers a decisive ruling of 4 to 6 years in prison, along with additional concurrent sentences. The final outcome is firm, structured, and irreversible. This ending reinforces the harsh reality of the justice system, where repeated offenses lead directly to long-term incarceration without further negotiation or emotional debate.
And also on that date, in a separate residence, did with purpose to defraud the owner of property, knowingly exerted control over that property without consent.
And principles of sentencing, the relevant seriousness and recidivism factors. The court has also considered the agreed recommended sentence of the parties and finds it to be an appropriate sentence. So on count 1, the court will order you to serve a minimum term sentence of 4 years, maximum term sentence of 6 years. On count 2, the court will order you to serve 12 months in prison to be served concurrent with count 1, and on count 4, 180 days in the Warren County Jail, that to be served concurrent with count 1 and 2 as well. You have 91 days jail time credit. The court's going to reserve jurisdiction with regard to the issue of restitution. Other than that, the court finds that you're indigent for the purpose of any fines, costs, or other financial sanctions. Which we spoke about a moment ago. Do you need me to go over that with you again?